Hello and welcome. Welcome to this special discussion on a topic that on the surface may seem dull and uninteresting to the average viewer or listener, but it is a topic which has occupied several election cycles. It has landed many public officers and private individuals in deep water with legal prosecution. However, it has also borne good fruit for the benefit of all St. Lucians. Today, an esteemed panel of experts will shine the spotlight on procurement, particularly public procurement, as they respond to the question, will the updated Procurement Act or legislation and the Electronic Government Procurement Platform, EGP, increase transparency, accountability, equity, and competitiveness in St. Lucia? I'm your moderator, Glenn Simon, Communication Specialist with the NCPC, and this is an activity for Productivity Awareness Week 2021. It is my pleasure to introduce our panel, and to my left, we have Dr. Claudius Preville from Preville and Associates Consulting Group, and you'll hear more from him about his expertise, and he will tell you more about himself later. We have also Ms. Cheryl Matre, who is from the Project Coordination Unit, and we also have Mr. Anthony Jean, who heads the Procurement Management Unit of the Department of Finance. And with us, virtually, we have Ms. Manuela Marlowe, Procurement Specialist with the World Bank. And thanks for joining us, thanks for being on with us, and I know that we have a lot to share. So we'll start off this morning where each panelist will introduce themselves, tell us a little more about who they are and the expertise that they bring to this table and their delving or their experience in procurement. So we start off first with Dr. Preville.
Good morning. Thank you so much, Glenn, and good morning, everyone. I'm Claudius Preville, and as Glenn has said, I work with Preville and Associates Consulting Group. I did economics. Economics is my forte, and but I've practiced a lot as a trade negotiator and trade policy advisor. So going back several years, I was one of the negotiators for CARIFORUM in negotiating the CARIFORUM EU Economic Partnership Agreement. And that was where I had my first major encounter with procurement. There's a chapter in the government procurement that is very relevant to our discussions today. In fact, I think so a lot of what is in that agreement was the cause for the new law we had in 2015 come into effect. I have also worked in several capacities as a consultant in Ethiopia, as an IMPRESS administrator on an EU contract where we had procurements of tens of millions of euros in different sectors. I managed that from the side of the EU. But I am also an active consultant where I bid on tenders, mostly EU contracts as well, but also, of course, St. Lucia government and the governments. So I have a good sense of procurement from both angles, as a contractor and as a contracting authority. And I'm hoping I can bring some of that experience to the table today in our review and assessment of St. Lucia's new procurement law.
Thank you very much. A wealth of experience with Dr. Preville. And we move to one closer to us. And Cheryl, you don't have to keep your mask on. We're actually creating a social distancing platform so that COVID does not present itself in any way or will affect you. And as our theme for Productivity Awareness Week says, St. Lucia, resilient, innovative, productive. So Cheryl, are you on? And tell us more about yourself. Yeah, you on. Your mic is on.
Good morning, everybody. I'm Cheryl Matre. I come from the Project Coordination Unit in the Department of Economic Development. I work primarily on World Bank finance projects, and my experience in procurement stemmed from 1995 when I managed a first World Bank project at the Ministry of Communication and Works. I have had a lot of exposure at the sub-regional and international level, having chaired the CARICOM task force on procurement, where we focus on the procurement reform, the procurement protocols for the region. Also, I have extensive training in disaster risk management, and I am a member of the Chartered Institute of Procurement and Supplies. Today, I want to bring to you my experiences, what has worked well for us in the Project Coordination Unit in terms of meeting our mandate, and what I think that government can do across the agencies in terms of implementation of this new Procurement Act. Thank you.
Thank you very much. A lot of experience there around the table. And now we come to Mr. Anthony Je. And he is the officer that everyone will be looking to really explain this procurement legislation because of his vast level of interaction and expertise with it. Mr. Je, tell us more about yourself.
Hi, good morning, everybody. My name is Anthony Je. I work with the Department of Finance in the area of procurement administration. The procurement administration unit evolved initially as an M&E unit where we were focused on monitoring and evaluating our financial administrative systems. But we realized that gradually this unit had to transition into more of a reform unit, because to make our monitoring and evaluating more meaningful, we had to make some fundamental shifts in the manner in which our systems were being developed. So we had extensive interactions with through assistance with the World Bank in terms of understanding best practices, and of course we had a heavy focus on ensuring that the practices we seek to adopt or adapt work in our environment. And we, in the last 10 years, this legislation has been 10 years in the making. We've had several experts review. We've had several interactions with our stakeholders, private sector included. Reform is something that the Department of Finance has constantly been doing. Back in my initial days with the Department of Finance, I am a career public servant. With the Accountant General's Department, we did a major reform in terms of reforming from a manual system to an electronic system. So again, the Department of Finance always ensured that these reforms allow us to transition into more meaningful methods of capturing data, reporting data, and strengthening the financial reform, the financial framework of the government of St. Lucia. So this legislation is something that I genuinely believe in. I think it's something that will work for St. Lucia, and I'm glad to have this opportunity to speak on it this morning.
Thank you very much. And I know you are going into some of the areas that we want to get into. So this will be a very active discussion. But let me allow our last panelist to introduce herself. And Manuela, a lot has been said of the World Bank and having the World Bank be so integral in terms of even the development of this new piece of legislation. So tell us about yourself and your expertise that you bring.
Many thanks, Ned, and good morning, everyone. My name is Manuela Mano. I'm a procurement specialist working for the World Bank, currently working in Latin America and Caribbean region. I work extensively with St. Lucia and other OSCE member countries, and of course, I work extensively with Mr. Jean and Cheryl. Before joining the Caribbean region, I used to work for the Europe and Central Asia region, where I had the opportunity to work on reforming the public procurement systems of a very diverse group of countries. I have been working in public procurement for 17 years now, holding a degree in law school and a master's degree in public procurement. I hope to bring the global expertise that the bank has on public procurement and various experiences of things that worked and didn't work well. Before joining the World Bank, I worked for the government of my country, Albania, in various positions related to procurement and public-private partnership. I'm honored to participate in today's event, and I'm looking forward to a successful discussion. Thank you.
Thank you very much. So we have great expertise around this table to actually decipher for us what is, this subject that not many persons pay attention to. But you always hear the issues around, every time an election comes around, you hear corruption, misappropriation of funds, and it all stems out of a procurement issue that may have gone wrong. But let's just go all the way back. But why is it important? What is procurement in its true sense? Mr. Breville, I start off with you.
Well, in fact, I think we were expected to make a short opening
Yes,
remark
you
on
could do
this.
that as well.
So I prepared something that I wanted to just probably just go through, just to make sure we capture all the points. What I want to say at this stage is that probably what we hear very much in the media and around election times about procurement has a lot to do with the direct public procurement, right, which we call direct awards. Everybody hear about direct awards,
Yeah,
direct awards.
yes.
And this, I think, gets the spotlight. It's even worse when you have an administration that seems to specialize in doing that. Then that becomes the only thing we seem to be hearing in the public, you know, direct awards here and there. For the greater part, from what I have seen of the law makes provision for direct awards. There's nothing illegal about direct awards. In fact, from my own interpretation, there are two major sections of the law that allows it, sections 52 and 53. 52 is where, personally, in my own concern is that it gives a lot of latitude to the minister, and a lot can be done. It really calls upon the discretion and the way he exercises his power under section 52. 53 is more straightforward to the extent that we are talking about emergency provisions. So while 52 really and truly it's powers given to the minister that he can exercise direct public procurement, and nothing in section 52 disciplines the whole question of thresholds, because we have the thresholds, right? We have the minor and intermediate and major procurements. What I don't see in the law is the interplay between those thresholds and the powers given in section 52. All right, so from my perspective, I think this is something that we may want to have a little more discussion on. I think the new law attempts to take St. Lucia a few notches beyond where we were in 2005. It's also my view that St. Lucia, since it ratified the EPA, the Economic Partnership Agreement that it did with the European Union, the EPA itself called for extensive provisions on especially transparency in government procurement, issues like having very clear technical specifications, bid challenges, methods of procurement, especially when it has to do with limited tendering and selected tendering. These are areas that were very thorny for us in our negotiations with the European Union. All these issues are areas of concern for tenderers. Like myself, most of the time nowadays I'm a tenderer, so I think I'm de facto wearing a tenderer's hat. And I represent also an associate of management consultants in St. Lucia. I have to say that for the greater part, many of my colleagues are not happy with procurement, the way procurement is practiced in not only St. Lucia, but in the region in general. There is a tendency very often that a tender comes out, it's in the papers for only 2 or 3 days, and then we hear it's closed. Or you bid on it, and then after 3, 6 months, a whole year, you had nothing back from the invitation. I mean, there's a lot of controversy involved in tendering in general, and I want to speak to some of those issues today.
So that's a lot of food for thought there. It seems that our procurement is not being handled properly. And I know that somebody who here, Cheryl, you do the majority of tendering, I think, for the government in St. Lucia. Your opening statement as well, and probably you could answer to some of the things that have been highlighted by Dr. Prevo.
Okay, I would like to start by giving an appreciation of two professionals of what procurement really is. Because at the end of the day, it is it's expected to be the driver that would give government the economic and social outcomes that they desire. And so you're looking at access to quality of life, access to quality of services, for example, healthcare, improve education, and a number of things. And so for us in the PCU, the Project Coordination Unit, over the years, I think from using the World Bank guidelines consistently, which I would say is synonymous to your legislation, we have been able to achieve our mandate. One of the things that we do is to look at a whole review based on indicators that we have agreed upon with the World Bank to see whether we are actually achieving the desired outcomes. And so for me, what I would really like to see out of this legislation is how we are going to monitor, how we are going to evaluate the system, how we are going to cause for us to have a cadre of trained persons, because as I say, within the PCU, the staff have been exposed to tons of training, and as a result of that, a lot of our capacities have been exported to the OECS, and that capacity is now strengthening and building capacities at the sub-regional level. So within government, I think we need to look at having having the legislation alone, which is very robust in its own way, will not work. I think that, and the EGP, I think that we need to get our players ready, and I think that is one of the problems that Mr. Previll is highlighting. We need to engage the market. We need to engage the players in the market so that they have an appreciation of the EGP platform. Now, the platform must be designed to enable them to participate. So connectivity is another issue. And I just wanted to answer Mr. Previll on Section 52. I think the new legislation has actually improved what was there in the previous legislation, because the previous legislation was open. And so the instructions had to come from the Director of Finance, which to my mind was lacking. But now when I look at Section 52 of the Act, it is more driven for the Minister of Finance to make a decision based on the market, because the market is what we need to use to determine whether a direct purchase is required or not required. It is not just, and if you look at it, it talks about where somebody has the exclusive right to provide a service. So just to note that, I think it's a major improvement over what we had before. Thank you.
Thank you very much. And just to indicate that the new procurement legislation really came into force this year, June of this year.
Yes.
And so there is some strengthening and there's some adjustment and learning that has to happen. And so there is a public education campaign that must go along with this. And so this is where Mr. Jean comes in to actually give us his opening statement. But also, you know, you have two presenters before you who have probably given you some additional points that you could raise as well and probably seek clarification on some of what has been said.
Well, yes, thank you. What I would like to say is that to put into perspective, generally government spend to 15 to 20% of the total expenditure via procurement means to acquire goods and services in the provision of public services. Approximately, in our context, that would be approximately 225 million annually based on our 2021 estimates. Through proper procurement procedures, it's possible to save, let's say, a minimum of 1% of that in a year would be $2.2 million. And the saving that can be derived from adhering to proper procedures can easily exceed that. I want to focus a lot of my delivery will be based on the purpose of the legislation, and to pay credence to what the previous speakers mentioned. The legislation aims to essentially simplify, clarify, modernize, make the processes more transparent. It requires competition. It seeks to increase public confidence and to be fair and equitable. The treatment to procuring entities, suppliers, it seeks to create a partnership arrangement where a win-win situation to say. And of course to provide increased economy and to aim for best value. Now I'm using the term best value. Best value does not necessarily mean the lowest price. It means, and I'm paraphrasing what's in the legislation. Best value can be derived based on the circumstances of the procurement, the requirement that you're aiming at, right? So in essence, the legislation seeks to set a standard at which government is required to approach these transactions. We have had experience where, in the case of World Bank procurements, they use the World Bank guidelines, which was a much more disciplined approach. And we want to see that sort of discipline applied across the board, a standardized method where when you deal with a particular agency, if you shift to another one, you have to learn their systems again, because everyone has a different modality in how they engage suppliers. We made it, we're seeking to set a standard by which all agencies operate that is supported by the legislation in a manner that works and assist our local competitors, our local suppliers, to be innovative, to grow, to develop capacities that would enable them to compete not just locally, regionally, and internationally, because a lot of the provisions in there were developed, like Dr. Triville said, through our learnings from the CARIFORUM arrangements. We received a lot of capacity building and training through that arrangement, and through a lot of assistance through the World Bank in terms of technical assistance. The CARICOM also has done significant work in the region in terms of setting a legislative framework that all member states are required to operate in harmony with. So all of these have been taken into consideration when developing the provisions of the law. And well, Section 52, which is a very attractive area, I have no idea why, speaks to direct public procurement. And the law does recognize that there are circumstances where, I like to call it sole sourcing, is the logical thing to do, the most efficient thing to do. Under specific circumstances, I would like to draw persons the attention to Section 52 actually prescribes the circumstances under which these that procedure can be, that method can be utilized. Of course, there's the issue where we must have appropriately trained officers who can use and interpret those circumstances in a manner that is advantageous to the government and, of course, to the suppliers. I always speak, whenever we engage suppliers, I know it's a tough sell to them, but single sourcing or direct public procurement does not always work in their favor. I've seen several circumstances where both the government and the supplier, through a single source arrangement, did not meet their procurement requirement, because it did not allow for the adequate planning and needs analysis was not properly done, right? So what the legislation seeks to establish is to bring a strategic discipline towards how the government of Indonesia acquires its assets by paying attention to the life cycle of that asset and observing the procurement cycle, which deals with carefully analyzing and understanding the procurement requirement, what it is you're trying to accomplish, developing your specifications, and based on those specifications, using a standard approach to sourcing and doing your solicitation. And in that process, it allows your market, and of course with the transparency that's built in, your market players get to understand your procurement requirement, affording them the opportunity to be innovative in how they respond to government tenders. So that in a nutshell is what the purpose of the legislation. As to how perfectly it accomplishes that, we have yet to see. The Procurement Administration Unit is charged with closely observing and monitoring to see where any shortfalls or many mishaps. I have never seen a perfect law. I'm not sure one exists, but I always say you can have a perfect law and still not have good procurement. However, you can have good procurement and no law if you have officers who are adequately skilled and understand, how procurement really ought to work. Thank you.
Very well. So I'm hearing a lot from Mr. Jean, And something that's been coming up, so I think our viewers online and our persons in-house better look up Section 52, because Section 52 looks like one of the more interesting aspects of this legislation. Manuela, Mr. Jam mentioned the World Bank quite a bit in terms of the procurement legislation matching up to the standards of the World Bank. You've looked at our legislation. I know that you've probably worked with ensuring that our legislation meets a certain standard. How do you assess our legislation currently? What are some of the things that you see within there that the previous legislation, this one creates more strengthening for it? And tell us about the process the World Bank has had and the involvement of the World Bank in this new legislation.
Yes, of course. I would be happy to say and to assess that the new public procurement law of St. Lucia is a very modern legislation. It's very in line with the best practices that we see around the world. It is an instrument that will allow more efficient and effective public procurement system. As Anthony said, that we're moving from the lowest price to the best value for money, to the fit for purpose procurement, and to more transparent approaches. And by saying more transparent approaches, we move away from the infamous clause 55 or 52 that leads to direct contracting. We hope that now the contracting authorities will have a full menu of options, of methods when they go into the market to better approach and better attract the private sector to participate. This new public procurement law is expected to, of course, in conjunction with the e-procurement, it's another powerful instrument. It's expected also to shape and to redimensionate the private sector. It will try to bring them on board of the new requirements. It will attract them and also make them partner, make them real actors in that. And that is the point that we will still have a lot of work that we have to support Anthony and his unit with. The fact that it still needs to strengthen the opportunities of private sector to complain, to address their concerns about the systems, and to have an efficient and good way of resolving those complaints. So in that view, we are happy to announce that this is a very good procurement law, but of course, as it was said from my colleagues, panelists, that it's not only about having the perfect law, it's also about having the right behavior and the right compliance attitude of the procurement practitioners. And that is why we also deem important to strengthen the capacities of the procurement practitioners in the country. I believe that Anthony will talk extensively on that, but we just finished heavy training of the procurement practitioners better understand what the mandate of the new law is and what is their role, what is expected from them. As it was mentioned, public procurement channel from 7 to 30% of total GDP of the country. So you can realize what is the impact it may have in the economy and what it can save and what it can flourish to an economy that really channels well these funds and make the good use of it.
Thank you very much. So now I'm going to throw out some questions, and I'm not going to point at anyone. I'm going to just allow for you to jump in and respond. So the ultimate goal of the procurement legislation is to save money and save the country money. Does that work? Is that working well? Have you seen good examples of monies being saved through the procurement process?
Do you want me to
You could jump in if you wish.
Okay, well, I'll jump in.
And you could also chime in as well on some projects that you actually see, local projects that you think there have been some errors, and how this procurement legislation probably could address that as well.
Okay, I mean, at this point, of course, I'm not here to judge the new procurement law. I mean, the law has just kicked in June. So really and truly, the procurements are just trickling in now under that new law, okay? So we're not here to judge the law at this point. But I think it's in terms of talking about our theme here about increasing, among other things, competitiveness. If we are going to increase competitiveness in St. Lucia, we have to start by increasing competition, right? So there's no way we could talk about will increase competitiveness if we are closed to increasing competition. And that's my starting point as a private sector individual. So I think what I would like to see fundamentally, Mr. Jean, is that we shift from the direct awards mode to a more competitive mode. That has to be, if nothing else comes out of our discussion today, if nothing else comes out of the implementation side in the coming months and years, what I would personally like to see is that government awards, let us say, at least 75% of all contracts through some degree of competition, however minimal or however maximum. The perfect one for me is open tendering. Open tendering, right? Of course, we realize that some procurements are so small. If you're procuring, let's say, just a couple $100,000 US, and you're trying to get services, you know, from people in Latin America and maybe in the US and other even more developed markets, I suppose it might not be attractive because the amount is too small. So in a scenario like that, you may have to look at a more local, you know, competition arrangement. But as a general rule, the procurements should be open. We should not have especially limited tendering, where we talk about, I just call John and Doe and the two of them make proposals, or even worse, I just call one company and they submit a proposal. Especially when we bring the thresholds into it, and I want to be very clear on that. If we are below the $100,000 threshold, and you say, okay, you're doing a direct award for whatever reason, we understand maybe the time you might spend going for procurement alone is way too much. It does not justify value for money to bother Mr. Jean and his team to go through a whole process for $100,000. But certainly, if you're looking at $100 million, and I heard contracts of that magnitude in the last few years being awarded for some kind of direct award modality, I am very, very alarmed by these kinds of procurements. And I think there's also the question of equity, because you see, when on the one hand, a small firm has to bid on, say, a contract for $200,000, you go through a whole process. You write a tender, you submit your bid, you put all your technical requirements in there, all your experts, you go through a whole process, which might take an entire week or two, just putting a proposal together. And eventually you go through the competition and maybe you're awarded the contract. But somebody else is not doing anything like this, and they're getting a contract for $10 million or $20 million. And I mean, even worse, what we have observed anecdotally, we haven't got the actual hard data in front of us in some of the recent procurements, but one that comes to mind is the procurement of, or the attempted procurement of vaccines for St. Lucia in the last couple of months. And from our perspective, there were some fundamental flaws in that approach. First of all, there was no tendering. And looking at the provisions on the sections 52 or 53, whichever one you look at, I couldn't see the basis for going ahead with a procurement in the way it was done.
But let me just put a spike right there. But
yes,
in your introduction, you did say that there is allowance for the Minister of Finance. So
absolutely.
If there is and Mr. Jean did indicate that there are circumstances in terms of procurement and there's flexibility. So is it something that we're saying that this new legislation needs to address, or it is that a blanket, it should just be done openly, no matter how urgent the situation is?
No, well, okay. I believe that, well, first of all, the urgency factor was not there in that attempted procurement. Why do I say so? At the time in question, St. Lucia had tens of thousands of vaccine portions on island. In fact, we were potentially running the risk of vaccine spoilage. We had gotten a whole bunch of vaccines from COVAX, right, in the tens of thousands. So there was no risk of vaccines running out into the foreseeable future at the time. That's the first point. So if there was a need for procurement, one could have gone through a systematic process of defining the requirements, getting the specifications, inviting a tender, getting the right individuals, etc. So That is the first point, no emergency. The second point is that because there were no clear technical specifications for that particular award, we have a scenario where a company that specializes in the production of cement, was somehow found competent to be awarded a contract to procure vaccines. Now, folks, something is fundamentally wrong here, because one of the objectives of government procurement is to ensure you are hiring persons, entities with the requisite skills, the requisite resources to undertake the procurement. So, if the technical specifications were properly drawn up, they should state clearly, among other things, that the procuring entity must have expertise in procuring at least medical supplies, if not exactly vaccines, okay? At least medical supplies. But clearly, the one that received the contract had not even those kinds of qualifications. So we have a multiplicity of problems there as far as I'm concerned. First of all, the problem of not having a qualified contractor receive the contract, which means it cannot perform with competence. And secondly, the direct award issue, which means $7.5 million going to a company without any competition. So these are the kinds of things that I think, from an implementation perspective, we have to find a creative way, right, to make sense of the procurement law. And I'm suggesting here that despite all the powers given to the minister responsible for finance, once a procurement is a major procurement, once it falls in the threshold of over $500,000, every possibility should be explored to see that it could be subjected to competition, right? If it happens to be like a Wasco situation where you only have one water company, we have to give it to Wasco. Well, I suppose we don't have a choice. Even then, and the experts in the procurement area itself, like Manuela and others, will probably give their own opinion on this. But I think even when there is a direct award, what should happen is the procuring entity should document exhaustively the criteria, and number one, and number two, the qualifications of the company that's being awarded, right? Even if it's one company, a monopoly. And number three, reference criteria in a close market, like say Dominica, Barbados, or Trinidad, where you could say the price being offered is comparable to the price in an adjacent market. So at least we're not getting our eyes dug out of our heads, as we say in St. Lucia, unfairly, okay? So my take is we need to ensure whenever we are going to exercise that prerogative of direct purchase, we dot the I's and cross the T's. And one of the things I would be interested in, my colleagues, Mr. Jean and Cheryl may have data on this, but I would really be interested in doing a study to see how we have handled procurement as a country for the last, say, 10 years. What percentage of our contracts will be in direct awards, whether we are keeping on file copious information about those awards, whether the companies being awarded actually have the technical capacity to be given the contract, and so on. Because this is really, for me, unless we address those things, equity and competitiveness will never be realized.
I think you raised quite a bit of issues there that I know our panelists will want to weigh on. And the issue of trust and transparency rings very clear with what you've been saying. And I know you want to answer the question, but I also want you to also answer this question that what Mr. Preble has also indicated there is that the issue of trust is very clear, and that you may not have the competent players being given the contracts. But I want to ask you this question as well. There's a fear from also other players in the market that the big players always capitalize on the procurement and that they never get a chance to win a bid because the same persons always emerge. Now, Cheryl, you could also respond to what some of the things that Mr. Preble has indicated, but I also want you to answer the question about whether or not the big players will keep getting the contracts because they always have the requisite skill or the financing to always win those bids.
Okay, I want to answer also your first question in relation to whether we can actually say that we have experienced savings in procurement.
Yeah, bring it closer.
Okay. As chairperson of the task force, and even when we worked on preparing the strategic plan for St. Lucia's procurement reform, one of the challenges that we found was that in St. Lucia and the rest of the region, we did not know what the procurement appetite was. We could not define exactly who were getting the contracts, whether it was nationals, internationals, regional. We could not define that. So our challenge has always been the capturing of data.
Data.
I recall at one point in time, Tessa from the procurement unit of finance was actually trying to go back through the records on Smart Stream and in Treasury, and other countries were doing the same, Barbados, to see if they could recoup that information. And I found that that was weak on our side. And so in passing this new legislation, I don't want us to focus a lot on compliance, but I want us to focus a lot on performance and results. And that is the only way we can tell who are getting the contracts. I mean, the World Bank has a very good app. And when I go on that app and I look at St. Lucia, I can actually tell you the value of procurement that is going out and who is getting the procurement, whether it's nationals, whether it's internationals, foreigners, and the type of methods that we use. So as I listen to the discussion that Mr. Privel is raising here, there's a need for us to make a paradigm shift in terms of how we have operated. There is a need for us to be able to look at probity in the selection of our suppliers. We need to make it a bit more transparent, because when I listen to him, in my mind, based on what I know happens in government, 75% of contracts do go for a tendering process, as in particular for us. We are to follow the bank guidelines, so we have to do competition. And I'm at tenders board almost every other week, and when we go there are other people there. So that means we have a functioning central tenders board, central public procurement board. We have the board also at other departments. So there is some level of competition taking place, but I think that the results are not posted, so people can see who were the tenderers, who got the contracts, and why bids were rejected. So perhaps that is an area that we would need to strengthen as we implement the new legislation. In relation to the direct award, this morning when I got here, I said it was something that I didn't really want to focus much on. But in all fairness, we must recognize that the direct purchase, based on the former legislation, the Minister of Finance would approve a contract based on a recommendation made by an accounting officer, and an accounting officer being a permanent secretary. And I would imagine that the permanent secretary would make that recommendation following technical discussions with the technical team. So the whole issue of the pharmaceuticals, which I don't really want to go into, I think the explanation needs to come out from the Ministry of Health in terms of why that recommendation was made. The other thing too is that the direct award letter from the Minister for Finance requests that the Director of Finance provides instructions as to how that direct award should manifest, and perhaps in the directions that the Director of Finance would have given, or the instructions, perhaps could have looked at the whole contract management in terms of what comes out, because the letter is clear, on the basis of the recommendation made by Permanent Secretary so and so, and that the Director of Finance will provide the further instructions. So that perhaps may have been weak, but I even look at our new legislation, and in clause 53, and it says there, whether country is impacted by a disaster, and we all know that COVID-19 is a disaster, or the life or quality of life or environment may be seriously compromised. So these are rules which any Minister for Finance can use, or any permanent secretary can use to make the case for direct contracting. I can tell you, based on my experience with the World Bank does not like direct contracting. We do not like shopping as well. And so the reasons for using direct contracting or single source selection, they set the basis when we can use it, and it has to be clear. So in our correspondence, we'd have to say exactly why we want to use the direct selection or direct purchase. And it is not just given. Technical capacities of firms must be assessed. Their financial capacities must also be assessed, because you do not want to give a contract by direct purchase to somebody and then to find out they do not have the technical and financial capabilities to deliver. So apart from looking at the need of the market, we also do our due diligence of assessing capacities from a technical and financial perspective.
So, Manuela, I want to come to you because you've been hearing the discussion, and the World Bank is being cited as having strong procurement legislation. Is it that our or can you cite whether or not there's perfect legislation anywhere, and that the procurement legislation is still left up to the discretion of certain persons in order to ensure that it is done properly? Is it that is the technical capacity of the persons that is seeking to have the procurement that has to be something that is the competence level must come there, or the legislation on its own should be strong enough to prevent any of those possible errors, poor judgment? Tell us a little more about that.
Well, the legislation is an instrument, but it's not everything. It's like having a powerful weapon, but it cannot guarantee that you are going to win the war. So, on that regards, I think that the pandemic revealed in global scale that even the countries that had the most modernized system failed to respond to the pandemic. I can cite cases of tenders awarded to gem companies for gem production, for ventilators, or even hundreds of millions of contracts that were never delivered, although they already got 100% of funds from states here in US. So I think that here we emphasize still the issue of having the technical capacity in place before we jump into procurement, and that is the first important phase of the procurement, that is the planning. And exactly the pandemic revealed that almost all countries, they were not prepared to respond to an emergency of this nature. And they didn't have the right instruments, the right thinking, the right strategy in place. Because it doesn't come to a procurement practitioner the fact or to know or the knowledge which are the suppliers in a vaccine tenders, or which is out there in the market. It rests with the Ministry of Health. They should be there to know and to have strategies in place, and to have also strategies in case of emergency procurement in place. Of course, we can always try to enforce the law, try to specify the law, to enter into it with the regulations and standard documents, and go further and further. But we cannot reach to the maximum outcome if we haven't done a proper planning up front. And also here, I will go back also to the competition aspects. We, especially in small markets like St. Lucia, we should be able to know where the private sectors that can participate in certain tenders. And there is the need to have a dialogue with these private sectors, to have these lists of vendors, of suppliers, to have their representatives sitting in the boards of the procurement unit of this regime, and they should make sure that they are represented, because currently, from our assessment in the OSCS countries, the competition is low. Then funds that goes to the national or public procurement that are not financed by MDBs, it is somewhere between two bidders in tender. The average is 2. while in the other tenders that have finances from other NDPs or donors, it can go up to 4 or 5. So it is a question of competition that we also need to think better and to try to strategize better in involving all of them. They also mentioned the open data, and I really need to point out that now that we have the procurement system that needs to be fully rolled out and everything should be channeled through procurement, we'll have better data to help us understand, and especially the procurement solution, understand what goes where and which are the suppliers, which are the vendors that get all these contracts. If there is any pattern there that needs to be carefully looked out and probably fixed if something is wrong with the system, or if there is other issues such as misuse of funds or corruption that also needs to be looked after and fixed, but only with having the reliable data in place and evidence that shows that something went wrong there. On the direct selection, I think that so far the region is having issues with that because the average is somewhere at 60–70% going to direct contracting. And here I go again back to planning and saying that sometimes we confuse emergency with urgency, and a good planning will also help us prepare for the emergency. If we leave everything for the last minute, then we will be in a situation of urgency and panicking and then not making the right decisions. But I also want to mention that procurement is not about having always the lowest price. It's about having the right value for money, or the right quality of the products and services that you are trying to purchase or to secure for your citizens. And also it's about having the life cycle cost of what to procure being the utmost, with the utmost quality and resisting through the times. So I will leave that with emphasizing the importance of good planning, close cooperation of technical teams with the procurement teams. It's easy to blame procurement on anything, but I think that it's procurement is a dialogue with many actors, technical team, procurement practitioners, and private sectors that needs to be strengthened and to be kept alive every day.
I want to come back.
Okay, go ahead.
Yeah, I want to come back in for a minute because and thank you so much for your presentation, Manuela, and also my other colleagues earlier. On the issue of the percentage of tenders that are awarded through competition versus direct awards, the question is not necessarily the number of contracts, but as far as I'm concerned, the value of contracts. Okay, just anecdotally, based on the numbers I heard flying around in the last couple of years, the size of the contracts I heard that were being done through direct awards, I can say anecdotally, in value terms, we were probably doing like a 70–80% direct awards.
But that's absence of data here.
Yeah. I'm not. Don't quote me on this. I'm not saying this is hard data. I'm just saying.
So news networks don't quote him on this.
Based on not news networks per se, but based on the fact that we were hearing 10 million direct award, 20 million here, 100 million, 50 million. It was just so many tens and even hundreds of millions of dollars we were hearing in direct awards, and I was hardly hearing anything. In fact, I hardly heard anything about those that were emerging through competition. Mm-hmm. Now, so my point, I'm coming back to what Cheryl was saying earlier on. I think the department has to do a much better job of itself at advertising, telling us, the people of St. Lucia, what it's doing in terms of those awards. The law actually requires that the minister lays before the parliament at least once a year a report on all public procurements by mode. That is not being done. Certainly, I have not been seeing it. If anyone has a copy of the Gazette where it is published, please tell me. I have never seen such a report laid down by the minister in the parliament.
Is that a requirement?
Right? It's in the law. It is in the law. So, but I want to say that the thing that makes it, and I know it's not the only discussion we're having other things to talk about on the procurement today, but the other thing that makes the public procurement by direct award such a problem is the extent of powers that are there for the minister, right? So on the section 52, which is what apparently is where apparently most of the power has been exercised, as opposed to 53. 53 is very clear. 53 is for emergencies, and there's a caveat to 53 that says where such powers are exercised in an emergency, the procuring entity must request a proposal or request a sealed quotation from the supplier. That's for 52. And for 53, it says the scope of the emergency public procurement is, as far as possible, limited to the period of the emergency, so that appropriate competitive public procurement procedures may be utilized at the conclusion of the emergency period. So the fact that an emergency exists does not mean that you should really use that as a basis for saying you're doing a procurement. You can use that if you could justify it firmly under the emergency. Otherwise, I think the only place to justify such a procurement would be under 52. In many ways, I'm not a lawyer, but I have done extensive work on trade law and negotiations. So I have a sense, well, I have been drafting legal text, but I'm not a lawyer, right? That's what we do as trade negotiators, we draft legal text. When I look at the scope of what 52 allows, it's a catch-all, right? For example, paragraph D under 52 allows goods and services supplied for constituency development program or any other program designated by cabinet by order published in the Gazette. This is a very broad catch-all category, okay? So I think there is a need to ensure that the protocols and provisions laid down in the standard procurement based on the thresholds, less than 100,000, up to 500,000, and beyond 500,000. I think every effort has to be made to ensure that competition is used based on the thresholds and less so based on the powers in section 52. Because as it is there, it is very broad, and it can literally, especially if you have the wrong individual driving it, he could use it to procure the whole country and nothing changes. So, and I'm sorry, but to a large extent we exercise, that's what we saw happening in recent times, in the last few years. So we really need to have, in as much as the law is very, very good, very powerful, we need to ensure now the implementing arrangements are equally strong, and there needs to be a kind of what I would call technical audit. There has to be a technical audit of procurements from time to time, at least once a year. I emphasize technical as opposed to financial audit. Financial audit could be a part of the technical audit, but we want to audit the actual procurement processes. Were they being followed? You know, did the first bid the criteria? Were the awards done in a fair way? What about time limits? And there is one clause I would like Mr. Jean and maybe Cheryl to speak about in the new law, where there is no provision made for the length of time that the evaluation committee takes to award a contract. So there are time limits on almost every other area. There are time limits for clarification, time limits for response when an award is granted, time limits for challenging, but there is no specific time limit on how long the procurement, the actual decision to make a contract award takes. And from the private sector perspective, this is not fair to bidders, because the bidders have to comply. There are so many strict guidelines for bidders, and I think on the procuring entity side there has to be some strict guidelines as well. For instance, we have to be compliant for up to 180 days. After we submit a tender, we have to be prepared to implement that tender up to 180 days later, right? Our bid must be valid for 180 days. However, there are scenarios where during that time, of course, you would have 3, 4, 5 other contracts come your way. So you may have a situation, if you're waiting for, at the 100th day, there's a new contract already awarded. So I think there has to be a little more equity in the way time use is managed in that procurement process, so that it's not in the law, but maybe, Mr. Jha, in the implementing regulations, maybe we could request the minister in the implementing regulations to put an upper limit on the length of time that the evaluating committee will spend for tender before a decision is taken.
So, Mr. Jha, you put on the microscope here, but also I want you to respond to certain things that have been said there by all the participants so far about the need for data and strong data collection. Do we have this built into the legislation? The technical audits, is it a requirement, and is it that we are not following that as well? And also, what has been very clear is that even what you said, that you could have strong procurement legislation but have bad procurement. Is it that one of the first things that needs to be done is that level of training for procurement officers? And are they professionals that need to be hired in order to ensure that we have good procurement? And also to respond to Dr. Preville, his concern.
Yeah, thank you, Glenn. There are so many issues that have been raised there.
So we have data, technical audit.
I'm not sure that I will have enough time to address.
No, we have enough
yes,
time.
Yes. Well, to begin with, I want to just add some clarity. The legislation, the Public Procurement and Asset Disposal Act of 2015, number 19, was commenced on 1st of June 2020. However, that commencement came with an amendment. So the document has been there's an amendment that came out in December 2020, right? And it amended several areas within the document. So the final document that was commenced included the amendments. So the section, I like to call it Area 52, which the U.S. government advises that person stay away from, has been amended somewhat, and the section that Dr. Preville referred to is not included in the final version. You would realize it only has 4 circumstances under which that provision can be utilized. To speak to the transparency and fairness built into the framework, the law essentially mandates that open tendering is the default method to use. It prescribes circumstances under which a restricted procedure can be utilized. And again, it prescribes the circumstances, and likewise in a single source arrangement. The transparency that's built into it, while yes, it gives the officers a degree of discretion in how they apply the provisions that allow for a restricting or even a direct public procurement. And I think Manuela quite aptly spoke to it early on in her presentation. She referred to the complaints and review mechanism. That is an important part of any transparency in a system where it empowers the vendors, the other stakeholders in your procurement to raise a concern. And again, that was brought in via an amendment 83A, where if somebody observes that a procedure is not being conducted in accordance with how the legislation frames it, they can file a complaint. And that complaint must be addressed within a certain time frame. On the issue of the data, well, again, we need to, prior to the Public Procurement Act, we operated under procurement and stores regulations. It created a loose sort of framework that was, at the time it was introduced, it was the best system that we knew of at the time, and we're going back into a system back into the 50s, or it was actually brought into legislation in 1997. But it speaks to the data that we captured under that system was the data that was being generated. Yes, we have data on contracts awarded prior to the Procurement Act, and again, that legislation does not mandate the sort of transparency. The purpose of that legislation was not defined as this one. Under this arrangement, it specifies the data that must be generated, captured, and reported. So Dr. Piril was quite correct in that report at the end of the period must be made a public document. And again, that is all part of the transparency that's built into the system. You spoke to the issue of big players versus small players, and again, that speaks to the equity and the fairness that the system tries to mandate. Although I'll challenge you to identify or get anybody to agree that they're big or small, by far a lot of our key stakeholders, our key suppliers, are emerging as small and most of them qualify as MSMEs. And the legislation seeks to create an environment where we can work with these agencies to build capacity. By requiring agencies to do the planning, and Manuela spoke to that earlier on, to clearly articulate, or as best as they can, articulate the procurement requirements, and we are required to publish government's intent. That allows for interested parties out there to be innovative in allowing government to achieve its procurement requirements in possibly ways that the procurement officer did not foresee. Because at that stage, I'm still planning. I have not gone to tenders yet. When I'm going to tender, I already have my specifications. I already have all my documents in place. But if the stakeholders are aware, suppliers are aware that, hey, it is government's intention to go into aerospace or whatever area, and we're putting out something there, you have the time to think about it and say, but hey, whether you're big or small, at that point it's innovation that matters. Who has the best ideas? You can put something together, ready yourself, so that when that matter actually comes to tender, you can come up with something that would cause person to say, hey, we need to think about this, and all that happens prior to you being ready to contract. So you're avoiding the situation where it's the 11th hour, your procurement requirement is already upon you, service delivery is at a standstill. So you're not in a situation where I have to do something now. Let me run to the Minister of Finance to get out of jail card.
But Mr. Chair, where is this information published? How do persons access it? So sometimes you have the same persons who probably have that information ahead of time or know when it's going to be published or where it's going to be published, and other players then have to run last minute. Is there going to be an improvement in that as well, in that area of transparency?
Yes. Again, the law was commenced in June 2021, sorry. So we expect to see a report at the end of this fiscal period on what happened during that period. And I think one of the panelists indicated that we really ought not to focus on compliance as opposed to performance, but the reports will indicate, it will give a sense of the level of compliance and how effective it has been, and it would give us a good platform to see, the areas that we really need to address going forward. The publishing of procurement plans would happen at the commencement of a fiscal period. It works in tandem with your fiscal accountability framework, your PFM legislation. So you would be required to publish that information at that time. And of course, agencies would be required. There is a compliance issue that we cannot avoid. We can't avoid in that agencies must produce that information to allow for it to be published. It's an important part of the framework. It is essential that it happens so that the system works in the way it should. And again, it would go back to the issue of capacity. Our officers must have the capacity to do proper planning, to properly define procurement requirements, to build specifications. Standard tender documents are prepared, are being piloted to allow for ease of compliance, to ensure that officers cover all the bases when preparing when effecting their procurements. And again, related to, there are so many issues there. Again, related to the data, we now going into the EGP aspect.
Yes, I wanted you to touch that aspect right away.
The magnitude of data that is required, that you're required to generate when approaching a government transaction, we're talking from the planning stage to the defining your requirements, right down to your contracting. To capture that data using a manual system, it's possible, but it has a lot of inefficiencies. The EGP seeks to address that by making that a lot easier. It automates the procedures, the workflows to make compliance, document handling, data capture, and reporting a lot easier. By this, it might take me an hour to design a report to capture all the contracts awarded in a period. But once I've done that, it's just a click of a button. Beyond that, they may be annually, you may want to do some upgrades to how the data is captured, but you have that in place.
So the issue of the technical audits that were highlighted by Mr. Preville, this would be a thing of the past?
I want to speak on that.
It's a thing to come. It did not exist in the past, and it is allowed. It is included within the framework to allow for that. We have engaged with the director of audit to ensure that they're aware of the provisions and that we are able to partner with them to ensure that that is done. There are specific provisions in the Act that in the event that you need to look into something, a specific circumstance, that you can't perform an audit. And again, if you read the section 83A, which we spoke to, is followed by 84, which speaks to a review procedure where persons can perform a review of a procurement process to confirm that there was compliance and that there was the outcome was in line with what the Act seeks to accomplish.
So let me let Cheryl jump in there. It looks like she really wants to answer
Yeah,
to some points. And let me just indicate while she's responding that we now have an open mic where you can ask questions, our in-house audience, as well as our virtual audience, ask questions of the panel or make suggestions based on the procurement legislation.
Mr. Preville makes a lot of provoking comments.
Mr. Preville.
And I think while we try to massage some of it, the realities are there. And I would say that St. Lucia has a lot of robust laws. And when the question first came up, my first answer was, of course not. It will not achieve. Because I just look at, for example, our traffic laws. And it's not in effect because we have the policing of those laws are not in effect because of monitoring. We don't monitor, we don't evaluate, and lack of funding as well. So for us to have any success in the implementation of this new legislation, there must be an advocate, there must be a champion to drive it. And when I say an advocate and a champion to drive it, I mean at the top level. This work in procurement did not start yesterday. It started a long time ago with the CARICOM. We went on, we got assistance from the EU to develop training manuals, and I have always said to the Ministry of Finance that you did not have to wait for a law to start training people, to start getting certification, to start engaging the public. And I think one of our fears was even to share the procurement plan. To share our procurement plan, our procurement opportunities with suppliers before. We had a fear of that. And I'm saying if this system is to work well, we must engage the players in the market, the small and the big players. We must design the program well enough because at the end of the day, government is there to build the capacity of its public sector. I am proud to say that within the PCU that there are contractors that have worked with us, that we have built capacity in terms of we have trained them, both contractors and consultants. They have been trained on the World Bank documents, how to prepare responsive tenders, and today they are bidding on bids in St. Vincent, in Grenada, and they are successful. So I think we need to leverage, use this act to leverage and build our local capacities, so that as the CARICOM bill comes out, our people can take advantage of emerging opportunities. Another thing I want to say is that the training has to be holistic. We have had a lot of reclassification and pay plan and looking at public service reform, but we have ignored procurement because we treat the job as a clerical job. We do not recognize that this is a very highly technical job. And I can tell you, when things go wrong in the PCU, procurement is always blamed. But it is not procurement in many an instance. And we now see that we have a number of PIUs, and people will tell you, procurement is delayed, procurement is delayed. It is not procurement that it is delayed, because you have to do the planning. And so you need the right technical people to develop the technical specifications. You need people that have an appreciation and understanding of the market, so you can know how to go out there and leverage. Now I heard Dean talking about financial audits. If we are going to use the services of the Director of Audit, that is a unit that we will have to strengthen, because when we're talking about procurement, we're not just looking at financial auditing, as Mr. Preville said. We're looking at matching the dollar that we spent against the outcome. Because as I said earlier on, procurement is the driver to particular social outcomes. In other words, how much time it took for us to restock drugs, how much time that we were out of drugs, how many people have access to this new school, how are we building new infrastructure and it is not being used, what is the cost of teacher downtime. This is the things that procurement must measure, so that we can say that there's efficacies in the system. Unless we cannot do that, or if we're just going to focus on compliance and not look at our performance of the system, I don't think we're going anywhere. So I appreciate what has happened over the years. We started off with a strategic plan, which had to be costed. We look at our key areas to focus on, which should have been the legislation, the regulations. But I think now we are at the stage where we need to employ holistic training and sensitization of both the staff in agencies of government and suppliers and users of the EGP. Because I saw in Jamaica, there was EGP, but people were still going with the big boxes to deliver the bids because they had no confidence in the system. Even as we have COVID, right? The Department of Finance has assisted and said, okay, people can make electronic submissions, but there's a limit in how much that they can submit electronically. So we had to say submit in multi-part. Then I still come to Central Tenders Board and see big boxes because people have no confidence in the system. So we must, it's a twofold thing, and I'm happy that we are having this here today, which is one in a long time. I'm allowing the public to get an appreciation and understanding of this new legislation, but it has to continue. Supplier engagement is key, and I think a plus for the procurement unit is linking our procurement planning to our budget planning. And so there we can pull out the indicators and then use those indicators to assess and evaluate the performance of the system. Thank you.
And that, one second, I want to actually throw a question to Manuela, so hold your thoughts there. And Manuela, what Cheryl said is very, very important. And should any procurement legislation actually have built in societal goals for when procurement is issued? Issues such as reduction in carbon and employment opportunities. Is that an important aspect that procurement officers and procurement, or should it be built into the legislation, or is it that the procurement officers should look out for those things? Because I'm saying this because While preparing, I went through a presentation made by a specialist for the EU, and this is something that they're indicating that is now part of the legislation, the new legislation.
Oh yes, indeed. Thank you for asking that. This is a topic very close to my heart. The fact that the public procurement law can carry and help being an instrument of applying other horizontal policies, such as social inclusion, gender, green procurement, and all other policies that are very important to the country. In that regard, I think that we have made here the first step, having a very modern and efficient public procurement law, but this is the first step of a long run. So I think that now everyone will see that their appetite has increased for more, and they will expect even more from the public procurement system. And also with the Internet of Things, we will look more, and we will constantly be in the challenge to develop and to change. It's very true that now with the climate change being the central topic of all our reforms and discussions, it will also come down to public procurement and what they can do and how they can contribute towards that. And it will come very soon as a requirement to try and procure sustainably and building back better. That is our new motto as World Bank. Will also look into very much into those things. We will try to look for sustainable sources, sustainable supply chain of what we procure, and that will also put a challenge to additional challenge to the technical teams and also procurement practitioners to look out for also this important aspect, also for innovation in what we procure. So it is very much topic of the day, and will be our next chapter of collaboration with Anthony. So I think we are there. We're looking into those aspects too.
And it goes back to what Mr. Jean indicated, that is not the lowest bid in every instance. And those sort of requirements from a bidder would be looked at as winning a bid. And I know that Mr. Preble, you wanted to chime in on something, and so to Anthony. So let me go to Mr. Preble first.
Yeah, thank you so much for that. I just wanted to make a couple of points in relation to the obligations that we already have, St. Lucia has in the context of the CARIFORUM EU EPA. Chapter 3 of the agreement, Article 169, that deals with the issue of limited tendering, right? And in part, the provision states that procuring entities shall not utilize such methods for the purpose of restricting participation in the procurement process in a non-transparent manner. So, I mean, I can tell you the heart of the whole negotiation on this chapter was about transparency and the inimical effects, frankly, to us when transparency is not observed. There's another provision that says the parties recognize the importance of transparent competitive tendering for economic development. Your question, right? So we realize that procurement has substantive value to confer welfare effects to any economy, but it has to be done in the right way. If it's being done in using the wrong methods, then the outcomes are compromised. There's a provision also where it accommodates, it encourages local development, St. Lucia in this case, to improve the balance of payments on our accounts balance of payments, right? So we have better export to import of goods and services. And that, of course, is a very big plus. There is another provision, 168, that deals with transparency as well. That one has to do with publishing the relevant tender documents and specifications in a media as soon as possible, meaning as soon as it becomes law in the country. So I think overall, I hope my colleagues from the Department of Procurement do not think that we're not having a fight today. I mean, they're my friends, you know. But as a tenderer, I want us to just, let them know the concerns of our sector. We are happy that we're seeing this direction of change. We think it's a very positive direction. But we'd like to see a lot more done. in relation to the remedies that exist now in the new procurement law. The remedies state in part that if a bidder challenges a particular award, he can request the Director of Procurement to make a review, but the Director can then decide to dismiss the matter. He can put it aside, he can perform a rectification, or he can do a revaluation, or he can pay damages. He has a lot of power, the Director. And it's not the regulations, maybe Mr. Jean, I missed it. Maybe the implementing regulations provide more direction on exactly how he goes about doing this. But ultimately, we can seek an injunction as well. Now, of course, we know our legal system in St. Lucia, right? We know how the courts work. So an injunction, I think, is like, well, we're not sure we're going to get a result unless another 3 months or maybe 3 years have gone by. So I'm not being cynical, but I think we've made some progress. I also recognize the World Bank input and effort in charting a new direction for us in this area. But I think a lot more needs to be done on the implementation side. And there needs to be more dialogue between the procuring entities and, you know, the vendors like ourselves to ensure we're on the same page. We thought colluding, we're not trying to suggest collusion in the procurement, but we need to understand each other's positions very clearly so that when procurements come out, we have a smoother and more, you know, rewarding process for everyone.
So that leads me to one of my questions. So, Mr. Jean, it's really coming directly at you, but is there a remedies regime within the public procurement legislation to deal with challenges from bidders in the public procurement process? And this really comes from many situations that you hear. St. Jude Hospital, for example, this has been going on for 12 years, and you hear of breaking down procurement issues. Can even a procurement that has been assigned be pulled back, taken away, reassigned, cancelled? What is is there a remedies regime that exists within there to strengthen this, so the country does not lose money unnecessarily?
Well, yeah. Well, to speak to that, primarily the law seeks to prescribe the standard at which government procurement is ought to be performed. It does speak to the areas of misprocurement where the provisions were not adhered to, like Dr. Breville outlined. You can seek a re-evaluation. In terms of, I get the impression you might be going towards penalties and that sort of thing.
Yes.
When it comes to penalties, you now go into the area of where the criminal code comes in. The law is an administrative law. It seeks to define the standard at which we're required to administer the procurement regime. If you violate any of the provisions in there, in your capacity as an accounting officer, in your capacity as a procurement officer, you fall under the purview of the public service, and the public service has its disciplinary regulations. Where a criminal act has occurred, be it fraud, be it liabilities are coming into play, you now go into the realm of, well, and again, I'm not a criminal lawyer, but that is the purview of the criminal code and its associated legislation. The issue of, I think there was an issue that was raised regarding the policy of what it is the legislation is trying to accomplish. And I think even Manuela spoke to the issue of sustainability in procurement and that sort of thing. The policy ought to be the overarching, what it is we want to accomplish with our procurement ultimately. I mean, everybody broached the subject from their perspective, which really adds value to that subject. Best value, lowest price, sustainability within your procurement. They're all nice, and I personally believe a lot in the aspect of sustainability in our procurement, given now the vulnerabilities in this part of the world, we have to approach these very cautiously. You have to inject a lot of realism into it. At the end of the day, you can't have sustainable procurement and still get low, go for lowest prices, or you now have to redefine how you do best, how you define best value if your policy allows for sustainability or green procurement. To infuse in an administrative law like that issues of penalties and remedies, it now takes it out of the realm of being an administrative law. And I'd much rather the Attorney General persons speak to that aspect of it.
So it does not speak to any sort of penalties.
That is not what I said. That is not.
It does, you know.
It does. It does. It speaks to it.
It does.
And but again, in the law, it provides a guide in the event that you breach the provisions.
I suspect
there
Mr.
is a
Shah doesn't
penalty.
want to say what the provisions are, you know, Mr. Shah.
And they're quite punitive.
Yeah.
The penalties for contravention include $20,000 fine, or I think it's EC dollar fine,
But
up to
arrive
8 years
that,
of imprisonment, or both.
Yes.
But I'm
So
hearing
either-
Cheryl saying there is no
there is
power, there's no teeth under it. What is it?
You see, it's difficult to speak to one provision in legislation because it's a cohesive framework. Now, Dr. Preble quite rightly referred to the issue of the review that by the director. The procedure for that would be outlined in the regulations. I mean, how you arrive at awarding a penalty, how do you indicate that procedure was not in compliance with the law? There has to be a very strict procedure that you follow to arrive at that, right? And of course, in spite of all that, an aggrieved bidder can decide to forego all that and just go straight to the court system, depending on the gravity of the situation. But of course, the law sought to allow within its framework for some sort of complaints handling, because again, the intention is to ensure that all stakeholders feel, fairly treated within the system. So it affords you an avenue within an administrative framework that you can raise a concern and get redress. I don't want to stress on it as being, punitive, really, but I like to focus on the fact that it seeks to define the standard at which we're all supposed to operate at.
So some persons have actually described the bidding process, particularly for bids above a certain value, as a very convoluted process, and it's quite involved. And I guess it's necessarily that way for the protection and accountability measures. But Manuela, should there be some level of flexibility? And actually the EU calls it flexibilization that goes into procurement so that you get the outcomes that you want. And it shouldn't be as so rigid that you cannot make changes. But again, it might tickle Mr. Dr. Preble, where he says, there should be very little direct purchases. But how is flexibilization worked into this legislation, and is it there within the current legislation? And also legislation that further, and also legislation that you could speak of in other jurisdictions as well.
Yeah, well, finding the right equilibrium is always difficult. Even the World Bank, since 2016, moved towards a more flexible procurement regime, because exactly for that, to allow more discretion and flexibility of the contracting authorities to make the right decisions and to find the best approach in the long run, not only driven by the lowest price. And having in mind a very important principle that is fit for purpose. So you need to take all these measures and follow all the procedures proportionate to the objective of what you want to procure. It doesn't make sense that for low values you open a tender, wait for 60 days for bidders to quote, and then run another 1 month of evaluation for small values. On small values, you need to be flexible and you need to be proportionate. We need to act quickly, and we need to act, of course, with integrity throughout the whole entire process. But that leads to a lot of issues related to the amount of discussion put into that. And I also go back into planning, because if we've seen contracting authorities that they will fragmentize their procurement plan to bring it all to small value and to go into the small thresholds and then make different choices when it comes to open tender. So that will require a large amount of work ethics, integrity, and also transparency since the very beginning. If you publish, as the new law is saying, that you have to publish your procurement plans in the beginning of the fiscal year, that allows for players on the procurement field, like these distinguished panelists we have here, to exactly do that, to complain to the contracting authority or to suggest to them to try to pull these packages together, to try to strategize differently. Increasing the transparency that this law is trying to do will also lead to careful decision making. It will also allow other important players such as attorney generals, the audits, to look into the initial plans and how they are implemented during the phase of implementation, and to see what drive the change, if there was any, or whether they were applied by having into the integral part the core principles on the law, like transparency, economy, and efficiency. So I think the instruments are there. The law allows for it, allows for the discretion with a proportionate amount, but also calls for a more active participation of other actors that will make this work and make the system function.
And Cheryl, I throw this question to you as well about the flexibility, and I know you do a lot of procurement. How do you find this area within the procurement process? Is it that you have a strict requirement and that's it, you can't waive, or there is your ability as a procuring officer to use your discretion and be a little more flexible in the procurement process?
Okay. Most times I hear people say that the bank is not flexible. And to some extent, the bank is flexible, and the bank will say, where you have national documents that work, so we can share templates ahead of time, they will agree to those templates for small value procurements. And so for those small value procurements, what we normally do is we bring the tenderers in, and then we have a discussion with them in terms of how to complete and how to submit. And then we also are allowed to receive quotations via email. It doesn't have to come in a sealed envelope. And so that allows us to expedite things. So we do it where it goes to a particular person, and it comes in the emails, and then but we ask everybody to submit at the same time, and then we open them at the same time for some, and then we have somebody witness for some level of transparency. Flexibility can only come about if you really know what is in the market, because it doesn't make sense to go through a long drawn out process when you know at the end of the day you will not get bids. And we saw that happen when we were trying to procure some met equipment. We did not recognize that that was a specialized type of equipment, and so we went out to the market, we extended until we only got one bid. And then after, when we started doing some more analytical work with the technical people, we recognized that it is only one supplier that can actually supply that piece of equipment. And so the flexibilities must come in where you have an appreciation of the market and where you can simplify documents, but at the same time to still holding on to the principles of transparency and accountability.
I want to.
Probably you'll still come in, but it leads me to a question here. And Manuela, you could also come in after Dr. Preville. But the EU has made amendments to their procurement legislation. Now, made amendments to their competitive dialogue procedure, revised their competitive negotiated procedure and introduced a new procedure called innovative partnership. Does the new legislation take into account such changes? And just for clarification, competitive dialogue is a dialogue between the authority and bidders to develop suitable alternative solutions to meet the requirement of the authority before award of contracts. And there is a slight issue with this, as you're saying, because it could mean that because you're going and asking a potential bidder what they think about something, and as Cheryl said, she didn't know the piece of equipment, this is what it leads to, so that you get probably even alternative solutions. Does the new legislation take into account those issues? But think about it while Dr. Previll chimes in, and we come back to you.
I think, okay, as far as I am aware, the EU's procedures, for the greater part, they are quite rigid. The EU says they've changed, but believe it or not, even small procurements, and is there an NAO representative here? Someone from the NAO office? No?
No.
Yeah, I would have thought you would have invited somebody from the NAO.
I think they, I'm not sure if they're on the live.
On the live feed. Because even for direct, what would qualify as direct awards in the EU context, they would still require the impress administrator to keep on file at least 2 or 3 comparable offers. Not because they are competing, but just to get a sense of what the pricing is like. So I'm talking about spending, I think in an Ethiopian context, was about 10,000 euros was the discretionary threshold. 10,000 euros was a lot of money in local currency. But we had to, for these very small procurements, we had to still maintain records of who could supply at that price and who we were choosing. Not competing, but at least having the basic data. For anything sizable, you would have to have at least a selected tendering procedure or open procedure. Open procedure was what we used most of the time. And the PRAG, as far as I understand, the practical guide the EU has still, to the greatest extent, it promotes the open tendering procedure. And which is where the portions of the law I cited early on from the EPA, right? These are all really from the EU's own legislation. So that's where that whole ethos came from and was brought into the CARIFORUM context. I want to say also that the NAO, for example, has strong competence in doing procurements for the EU in St. Lucia. They understand the EU rules. So it's not that we don't understand EU procedures and rules, we do. We can use the EU rules and procedures, then we use our own procedures. So I ask myself sometimes, well, why do we want to use the more efficient rules if the donor says we must use those rules? And then if the donor says, well, if it's not the donor, then we use the less efficient rules. You know, so we know how to use the efficient rules, you know, but somebody has to be policing us to use the more efficient rules.
But I think what was said earlier.
The main comment I wanted to make, though, was on something called design build finance.
Okay.
Just to move away a little bit from the earlier discussion, it's a mode of procurement in the construction sector. And one of the excuses we heard of the previous administration for doing so many direct awards was because of capacity of the contractor to supply design build finance services. So essentially they would do all the work up front and then bill the government afterwards, right? It's great for government cash flow when you have a cash flow issue to government. But then, couldn't we have done something where we invited calls from a number of design build finance companies? Because it's not only one company that can do that. I know off the top of my head about 6 companies that could do design build finance. So if the issue is, okay, we will procure roadworks for design build finance, let's get 3 companies. Let's pre-qualify 6 companies. Let's get whatever number 4 or whatever to bid, and we will get the best value for money from that, because in this competition they would compete more on the interest rate that they would offer, Mr. Shah. They would compete on the interest rate that they would bill the government the money's on after the works have been done. So someone might go like 8%, some might be like 7.5%. But essentially the government gets bankrolled up front and has to pay back. So it's like a government bond being issued, technically, right? but the price is controlled by the contractor, right? So I'm saying in a case like that, we should seek proposals from at least 3, maybe 5 companies that can do design build finance with the capacity. Let them make offers, and the best offer would be chosen, you know?
Yeah. I think it is almost in sync with the question, Manuela, about the competitive dialogue procedure and activities of that sort. So, do you want me to repeat the question, or you're ready to answer?
No, thanks. I would like to say that the competitive dialogue and this kind of negotiations are also in the World Bank procurement framework since 2016. But these are very specific approaches that are applied to very large contracts throughout the world. The application of these methods or approaches is very limited so far. I can say that from the World Bank in the entire world, it may have been used twice. And that goes for large projects such as power plants, power grids of very large countries such as India. So these kind of approaches are not very proportionate to the size and the market of solution. The law allows for the most economic advantage tender, and that's a very good thing. From that, it gives the discretion of the contracting authority to choose the best solutions and the best bid of what it was offered. We don't have to overcomplicate legislations. They have to be a mirror of the situation of the market of St. Lucia. So I think that what the current Procurement Act entails is sufficient if it's well regulated in the procurement regulation, and if it's implemented well and into compliance from the contracting authorities. Of course, going further, if the market changes, if there are some very large procurement contracts that would request for specific methods, they can always have an enhancement of the legislation. But from what I see, I don't see that in the foreseeable future the government of St. Lucia would need to endorse highly complicated procurement approaches.
Very good. So that answers one of the questions that I had about the legislation being very simplified, simple enough that persons, an ordinary person, could actually understand it and would participate in the process. So we're actually at a point where I would like for some closing statements actually from each person, very short, about a minute closing statement, so that we could bring this discussion, very interesting discussion, very rich discussion. We had no questions from our in-house panel. I guess they were absorbing, you know, a lot of the information that was coming out and that came out from this discussion here. So we start off with Mr. Jean to really give us his closing on the discussion at hand.
Well, thank you, Glenn. It's actually, the discussion is never over for me. We continue in this mode of trying to grasp the different perspectives on how our procurement ought to work, and our job is to try to explain how the provisions of the law allows for that sort of transparency and fairness that we're aiming through. That is the purpose of outlining the purpose of the legislation. Through this morning's discussion, a lot of very interesting and meaningful perspectives came out, and I'm hugely appreciative of that. I think the legislation and what it is we're trying to accomplish with our limited resources is trying to address these issues. How optimally we can do that, I mean, it is a mammoth task indeed, but it's something that is on our work plan. It is something that we have in our sights. A lot came out as to the practices that we actually have vis-a-vis what it is we say we believe in. One of the theories on that is that it's one thing to believe in something and practice another, but essentially what it boils down to, you actually believe in what you put into practice. So it's something for considering in terms of, I think Dr. Priville spoke to how we can do follow the World Bank procedures, follow the NO procedures, but when it comes to our own GOSL funding, we seem to go to less efficient and less proficient measures. So these are the challenges that face a procurement regime. There are many theories as to what's the best way. We're not naturally evolving this. We're trying to infuse practices that work, that we have seen work in other jurisdictions, and trying our as best to localize it. And it is a huge task. We have to partner with our stakeholders. That must never be overlooked. Our vendor community, our procurement officers in all the agencies. You can't develop one aspect and neglect the other. It is a challenge that is before us, but the benefits, I mean, it wouldn't take you 10 years to see the benefits. It's something that you will see the benefits almost immediately once you put these practices into play. Thank you all for this opportunity, and we look forward to a lot more of that sort of discussion and debate.
Thank you, Mr. Chair. And I know that the procurement unit, this is part also of the education campaign on the new legislation. As you see, I'm sporting my new shirt, which they've given me. It's a procurement issue, however. It's very tight on me. But we'll address that. I'll have a complaints review. The complaints review section of the legislation will be looked at for that. Manuela, we come to you, and then we go to our in-house, so then Cheryl, and then we'll end with Dr. Prevel for your wrap-up.
Thanks, Leanne. You see, procurement tries to shape staff and people and markets, so it is like an incentive for that kind of show. Thank you for having me. I want to congratulate the government of St. Lucia, Minister of Finance, Anthony and his team for this enormous report that they put in to introduce the new legal framework on procurement, to embark on this very important step. And as I said, that this is the first step of the long run. We now have in place the e-procurement that makes St. Lucia one of the first countries in the region to have that. And I think that having the new law, having the new bylaws and regulation, and the e-procurement system lays a very solid foundation for the future to come. We all expect a lot from what has been done, but we also must recognize that this is a very important step forwards, and we need to work together. I think that World Bank will continue to be a proud partner of government of St. Lucia and people of St. Lucia in supporting this kind of reforms. Thank you.
So St. Lucia is doing some first here once more. So that means that will be used as a pilot project. I know the World Bank will quote us everywhere as St. Lucia has done this, I know.
Absolutely, and we take a lot of pride in it, and we should too.
Thank you, we are. So now it brings me to Cheryl to give her wrap-up.
Thank you. I'd like to thank the Department of Finance for inviting me to this discussion. I think it was very useful. I know we asked a lot of questions. We placed a lot of pressure on the Department of Finance when we first hit with COVID, because we impacted severely. Our project implementation was delayed for all of our World Bank projects. We could not have bids come in. We could not have physical opening of bids. And so there were some measures that were put in place. And then now with the e-procurement, EGP, I know that that would also help us now, so that we don't have to use the email address anymore, but I want to remind us that public procurement and legislation are only instruments to good governance. And there's quite a lot happening. I mean, you can look at in St. Vincent, where Bali and Bali appealed to CDB. They also appealed to World Bank based on procurement processes not being followed. You can also look at what is happening now in the BVI. I read on the weekend of a contract being waived, and then Cabinet awarded the contract. And when I look at our situation in St. Lucia, I am saying that we are one of those that have a very good system in place in terms of not having too much political interference, in that you do not have to go to the Cabinet for approval of contracts like Grenada and Dominica would have to do. I mean, you have a board, they charge you for a mandate, but now we have to ensure that that board reports or the departmental board's reports, and it is published so that comments like what I hear from Mr. Preville, we can minimize those, because it's not just stating them in the law. Dean, I think you need to start looking at a structure for your unit in terms of how you're going to monitor and evaluate the performance of the procurement framework, the regime. I think you would have to work closely with the Director of Audit in terms of looking at the type of staffing that would be required to undertake those technical audits. I know they do procurement audits for us, but then the technical audit is also important in terms of evaluating performance of procurement, because I think sometimes we forget that procurement includes the whole aspect of contract management until you get out to close out of a contract. It's not just the award, but how well is that contract performing. Another thing too is that the whole thing, we had a lot of work done with the EU. We did look at the EPA in terms of developing the model legislation for the region, and a lot of curricula was developed, and I think we need to go back, look at that curricula, and use it also as part of our training. I also think that there must be more collaboration between agencies, in particular the Department of the Public Service and the TVET unit, in terms of looking at how now we cause procurement to become a profession in government, as well as developing standards that we can use for certification of persons that are already working in procurement but do not have the necessary certification or qualification. Dean, I expect to see you a little bit more on the program called the Red Seat, where the public will now start understanding what the Department of Finance is doing in terms, so that we can start building the confidence of private sector, of the small players, so that they would be willing to participate. I know it's challenging, and I think based on earlier statements that I have heard from our Minister for Finance, I think you have a strong advocate and champion that you can use moving forward. I know resources are limited, but I think with discussion and collaboration with agencies, we can piggyback on some things that are already there in terms of enhancing and improving the entire procurement framework. Thank you.
Wow. I told her 1 minute, I did. I did say 1 minute. But Cheryl did make a lot of important points, and Dean, you have an advocate, so when you start the education campaign, you could piggyback on Cheryl to support you on that, because I think it is, all what she said there is well placed, and also there are opportunities for employment for young persons. We always have our young persons thinking that it's a doctor, it's a lawyer, and maybe procurement. If you tell them the dollar value, I think you said that sometimes a procurement could like $1,000 US an hour. I'll be signing up for those classes as well. So, Dr. Preville, the wrap up is to you, and I'm watching my clock here.
Don't worry, you have to watch too long, Well, okay, first of all, I want to say I'm very grateful and thankful for this opportunity to be with you today. And the discussion was quite lively, quite enriching for me, and I learned a lot from the procurers themselves, those who actually do the work. And of course, you heard from us, those of us who do the tendering on from this side. I think it was a very good dialogue, and I would like us to keep that going. I approach everything with a high degree of optimism right now, because I think the law, as I see it, the procurement law has certainly captured lots of the elements of the CARIFORUM EU EPA, which is like the biggest, quantum leap in procurement for St. Lucia since the early 2000s. So that's very commendable. I am a skeptic of Section 52 and 53, and I'm sure you've heard a lot about that today from me. And I'm not the only one, by the way. I think the lion's share of St. Lucians are very skeptical of these two sections. And I think it would be very helpful for us to do many more publicity events on this. There is a need for very large scale national advocacy on what's in the procurement law, what our rights are, what we need to know as St. Lucians, the issue of the need for the Minister for Finance to present a report to us annually through the Parliament on what was done for the year in the procurement, public procurement. I think that needs to be done. I believe the new Prime Minister is committed to doing this, and I expect it will be done under his watch. I want to also say that the importance of procurement plans cannot be overemphasized. If departments have very clear plans from the start of the fiscal year, you will know exactly what kind of procurements need to be undertaken, because it's a process. You know, it has to go through an approval process. You have to get technical specifications. You have to procure the right consultants, etc. So there's a whole process there. And to avoid the temptation of going to use Section 52 to hire your consultants, I think it's good to have very good procurement plans from the start of the year. The technical audits, I personally want to see what has transpired with our money as St. Lucians for the last, say, 20 years. I want to throw a challenge out to Mr. Jean and Cheryl to commission some work in that area. We really need to see what's been happening to the spending of St. Lucians' money in public procurement, and not only to know what the money amounts are, but have they been spent in a judicious way? And what are the results? Can we say that we got value for the money spent? You know, we need to really get that done. I would also want, once we know what we are spending now in direct awards versus competition, I would like the government to set a target percentage of procurements that they will do annually through competition. I think that would be a good way to start. So let us say we are at 25% now, competition for in any 1 year. Let's set a target. Maybe next year it can be 50%. In the years to come it might be 65, 75%, you know. But I think it's important to put in place a mechanism that will, over time, we will know exactly how well we are doing, how well we are serving the public, how well government is serving the public, whether you're meeting your targets, etc. And finally, I want to say again, thank you so much for this this discussion, and I'm looking forward to more of these. I think it's important for St. Lucia and the OECS countries. By the way, there are regional agreements on procurement. Some of what is in the law here will not impinge upon. And there is the other issue of procurement of statutory bodies, like SLASPA and WASCO and the others. They are not covered directly under St. Lucia's procurement law, but tangentially they're important to St. Lucia, especially in the context of national debt versus the public debt. Okay, so some of the debt that WASCO and SLASPA and others might take on would ultimately impact not the government's debt, but of course the national debt. Yeah. So we need to keep some kind of interest as well in these procurements, while of course their own local acts and legislation would govern the procurements done by those agencies. Thank you very much for inviting me, and thank you for your patience and time. Thank you.
Thank you very much. Thank you to all our panelists. I think it had a very rich discussion on an area that I said in the beginning didn't seem to be as sexy, involved. It was dull and boring, but it isn't. Procurement is very involved, and it requires us to pay close attention to it so that we could get the best outcomes, allow our country to save money, and that we could utilize that money most efficiently. And just to repeat, procurement, public procurement is a comprehensive process stretching from procurement planning, budget allocation, bids invitation, bids evaluation, contract award, contract management, performance evaluation, and auditing and reporting. The public procurement aims to ensure the application of fair, competitive, transparent, value for money standards and practices for the procurement and disposal of public assets in the public sector procurement process. The new public procurement legislation seeks to reduce the level of distrust in the system, reduce corruption, increase transparency, equity, and accountability in the system. I would like to thank all the panelists for their excellent contributions on the topic, and the in-house and virtual audience for their participation. We thank the NCPC as well for including this topic as part of the Productivity Awareness Week activities. And please follow us on Facebook for the repeat of this program, or on our YouTube pages at St. Lucia NCPC, STLUCIA NCPC, for the repeat of this program. I thank you very much for your attention and have a wonderful and productive day.